Welcome back. In this video, we're going to be tackling the subject of secured transactions. And this chapter is primarily here for those accounting majors out there who aspire to take the CPA exam, because notoriously this is one of the topics covered on that exam. So in that regard, I have included accountants in this week's Lawyer Joke of the Week. And it's very short. It goes like this. What's the difference between a lawyer and an accountant? Accountants know they're boring. All right, there you go. See, we've spared no expense here at the WIU Business Law Studios for your enjoyment of the Lawyer Joke of the Week. In fact, I'll throw in an extra one because that one was so short. Another joke along the same lines is, what do you get when you cross a lawyer with a pig? The answer is we don't know. There's some things that pigs just won't do. Okay, well, let's get started with our topic here of secured transactions. This all comes from Article 9 of the UCC. Remember earlier in some of the previous chapters we've been talking about Article 2 of the UCC that deals with contracts for the sale of goods. Now we're moving on to Article 9 that is all about the rules of secured transactions. And we can see Article 9 applies only to transactions intended to create a security interest in personal property or fixtures. That's what we mean when we say a secured transaction. All right, for those of you who may be coming at this for the first time, this topic in general, there will be a lot of new terms and some of the concepts may not be familiar with to you. So what I thought I would do is I would just start with a very simple example of what we mean when we say a secured transaction. Okay, so I have one here on the slide. We have, let's assume, Bob's garage. And let's say Bob wants to buy a new piece of equipment for his garage. And so he goes to the bank to borrow the money because he doesn't have the money to pay cash for it. And he wants to buy one of these diagnostic machines that the mechanics put on the newer cars to read the car's computer to find out what the problem is. And he thinks he'd be able to fix a lot more newer cars if he had this piece of equipment. So he goes to the bank and borrow the money. So we see the first line there. Bob's garage goes to the bank gives him the money, and in exchange, Bob signs a promissory note, right, to repay the amount of money that the bank is giving him over time. And in addition to that, he signs something called a security agreement. And it's an agreement between Bob's garage and the bank that when Bob goes out to buy this new piece of equipment, if Bob doesn't repay the bank or defaults on his promissory note, then he gives the bank the right to come and repossess his equipment and sell it to secure payment. So that's really what we're talking about here. These are all the transactions that we're talking about, is using personal property as collateral for obligations to secure payment. So we see here in the next line, Bob goes out and buys the piece of equipment, the diagnostic machine. He brings it in and starts using it, but things at the garage don't go well. And Bob defaults on his loan to the bank. He misses a payment, for instance, and he's in default or breaches his contract with the bank by not repaying them like he promised. Then, under the terms of the security agreement that Bob gave the bank can come back to Bob's garage and repossess the piece of equipment that was security for the loan. So this is the type of transaction that we're going to be discussing. There's going to be a lot of new terms and a lot of examples and concepts, and we're going to have rules and exceptions to rules, but if we just remember that basic example, that's what all this comes back to. All right, so let's get started. I'm not going to go through, some of these slides also are pretty long with a lot of terms on them, and you can go back and refer to them later on as you're studying. I'm not going to go through each of these terms in great detail, but I do want to just sort of introduce some of these things before we get into examples. So, unique terms under Article 9. Well, goods is not unique. We know that from Article 2, but goods is typically anything movable and tangible, personal property, except for things like money, securities, certain legal rights, patents, copyrights, intangible, things like that. Article 9 also breaks down goods into certain categories. And so we can see some of the categories here. Consumer goods. Consumer goods are primarily for household use, personal, family, or household purposes. And we're going to have some different rules later on about consumer goods and the rules for perfecting interests in consumer goods and those things. Farm products, those are crops, livestock, supplies used directly in the farming operation. Inventory. We're going to have some special rules for inventory later on. Inventory, of course, are goods held by a merchant for sale to the public. Right? So if you go to Walmart, it would be all the merchandise that's out on the floor available for customers to buy. That would be their inventory. And equipment. Equipment, of course, is property used in the operation of the business. So like in my previous example, the diagnostic machine that Bob uses in his garage, that's a piece of equipment, and that can be collateral also. Fixtures. Fixtures is one. It's a category of goods. It's a kind of a quasi-good and quasi-piece of real property or land, because fixtures are goods that have become firmly attached to real property. They start out as goods, but then they're attached to a real property in a way so as to remain permanent. So they're going to stay put. That's a separate category of goods called fixtures, and we'll have some rules for those too. Another term that we're going to use a lot in this chapter, and that's the word debtor or obligor. Right? The debtor is the person who has some original ownership in the personal property that's being used as security, and it's the person who's obligated usually to repay some money that the debtor has borrowed. But it could be any other obligation that is secured by personal property. Again, long list, and I'll run through these very quickly, but more unique terms under Article 9. First, security interest. We'll be using this one a lot too. A security interest is just a term that describes the interest in personal property or fixtures that secures performance of an obligation, usually the repayment of money. Secured party. I will probably use the word creditor and secured party synonymously throughout the chapter. I kind of flip back and forth in using that, but a secured party is a party who holds the security interest. This is usually, like I mentioned, the creditor or the obligee, the one who receives the performance or payment from the debtor. Collateral, I've already used that term in our video so far without really defining it, but collateral is property, and in this chapter it's going to be personal property, that is subject to a security interest and the right of repossession by the secured party upon default. Security agreement. Security agreement is the agreement, the contract between the debtor and the secured party that gives the security interest to the secured party. Default, again, I've already used that term. Hopefully you were familiar with default. It's similar to or the same as a breach of a contract, right? Default is when the debtor fails to pay or satisfy some other obligation according to the agreement. Repossession. Repossession is the right of the secured party to take back collateral because of the debtor's default. And at the end of this chapter, we'll see what rights secured parties have in repossession and what they can do with the repossessed property. Attachment. These next two terms are going to be very important in the chapter. The first part of the chapter, actually, we're going to talk about these two terms almost exclusively. The first is attachment, and the next is perfection. Attachment is the process of the secured party obtaining a security interest in the collateral. Attachment deals with the rights of the secured party as against the rights of the debtor to the collateral. Perfection are steps the secured party must take to protect rights in the collateral against people other than the debtor. So when we talk about perfection, what we're talking about is the rights of the secured party in the collateral as against other secured creditors. Because as we'll come to find out, sometimes debtors give security interests in the same collateral to more than one creditor. And so when the debtor defaults, then it's a fight usually between the creditors as to who has priority to that collateral. We'll deal with all of that, and it has to do with perfection. Financing statement. Financing statement is a document filed by the secured party to give notice of their security interest in the collateral to the public in general. We'll talk about perfection by filing a little later on. Okay, types of property covered under Article 9. And again, there's any number of types of personal property out there that a person can use as security, but these are some pretty common ones. Obviously, if you look down at the bottom of the list there, we've listed goods. Goods are typically what we refer to when we're talking about Article 9, but there are other types of property, personal property, that are out there that can be used as security too. Goods, we've already mentioned consumer goods, farm products, inventory, equipment, those things. But if you look back at the rest of the list there, we can use other types of property as security that wouldn't immediately maybe come to mind. Instruments, things like drafts, checks, promissory notes, CDs, stocks, bonds, those kinds of things that we would have ownership of. We can use those as collateral. Investment property like brokerage accounts. Documents of title. We haven't really talked a lot about this. We did a little bit in our chapter on risk of loss and ownership and those things. But there are some documents out there called bills of lading and warehouse receipts. And really what those are, they're documents that indicate that one person owns some fungible goods that are being stored in a location with other people's goods. So like a warehouse, for instance, or a tank. Like if I own 1,000 gallons of gasoline, and the gallons of gasoline are contained in a tank that holds 10,000 gallons, and I have 1,000 of the 10,000 gallons. Well, I will get a document of ownership to 1,000 of those gallons, because it doesn't matter, which gallon it is that I own out of the 10,000, but I need some sort of proof that I own, 1,000 out of the 10,000. That would be either a bill of lading or a warehouse receipt. Those are kinds of documents of title that we're talking about. Also, accounts receivable, the right to receive payment. I can use that as collateral. Deposit accounts, I can use any money I have on a savings account or other deposit account. I can use that as collateral. In case I don't pay, then the creditor can come in and take the money out of my deposit account. Commercial tort claim. Now, notice it doesn't say personal tort claim, like a personal injury claim. If I get injured in a traffic accident, I can't assign my right to sue a person in that kind of a claim. But if it's a commercial tort claim, it's my business has a tort claim against, or a lawsuit in civil court against another business, I might be able to use that as collateral, right, as security for my payment of another obligation. General intangible things, copyrights, patents, goodwill, things like that. And then there's this funny sounding one, chattel paper. And we're going to talk more about chattel paper because there's some specific rules about that later. But chattel paper really is a consumer sale on credit, like an installment sale to a consumer. So chattel paper is the paper or the agreement by a consumer to make a stream of payments over time. I can use that paper, the right to receive those payments, as security to satisfy my obligations to another creditor. And we'll talk more about that as the time comes. So let's get into attachment, and we'll start talking about attachment and why it's so important and what the big deal is. First, attachment of a security interest. Once a valid security interest has been created, it is said to attach to the collateral. The secured party's rights attach or adhere to the collateral and gives that secured party the rights in the collateral from that point on. So what do we need for attachment? Well, we have the elements here. First, a security agreement needs to be made between the debtor and the secured party, and either the debtor's signature on a written security agreement and an agreement describing the collateral or secured party taking control or possession of the collateral. So we have a couple of things here going on in our definition. So we have a security agreement and either the debtor's signature on an agreement describing the collateral. So we have a writing with the debtor's signature. Or if we don't have a writing, we just have an oral security agreement. We can still have attachment if the secured party takes control or possession of the collateral. We'll talk about control and possession in a minute. So we don't require a writing for a valid security agreement, but if we do have a writing, it has to be signed by the debtor and it has to generally describe the collateral. Our second element there, the secured party has to have given value in exchange for the security interest. Usually this is a loan, right? So this is talking about the secured party, think creditor, who gives the debtor something of value in exchange for the security interest. And then last, the debtor has rights in the collateral. Normally this is ownership rights in the collateral, but it doesn't have to be. A security agreement is valid and will attach if the debtor has any rights in the collateral. And sometimes this could be just the right to possess the collateral under a lease or a bailor-bailee relationship or something like that. Okay, so those are the basic elements of attachment. Let's go through them in a little more detail. First, an agreement. We need an agreement. We need an agreement between the secured party and the debtor in order for attachment to happen. And like I mentioned, the agreement can be written or oral. Written agreements usually contain a description of the transaction, what is going to be exchanged. Think contract, right? This is usually contained in the contract between the debtor and the creditor. It will include usually a description of the transaction, a description of the collateral to be used, the personal property that's going to be security. It can be somewhat generic unless it's for consumer goods. Consumer goods we're always going to treat a little bit differently under Article 9. But it can describe things like all equipment now owned or hereafter acquired by the debtor, so a general description. Consumer goods, though, are going to just require a more detailed description. And the parties' names, the parties involved, the secured party and also the debtor, and the terms of default. In other words, this is the contract. This is the agreement between the debtor and the secured party. And so usually in the written agreement especially, we'll have the terms defined, terms of default. What constitutes a default? Non-payment, late payment. Sometimes there are other obligations that the debtor has to satisfy, like sometimes the security agreement will require the debtor to maintain insurance on the collateral. And if they let the insurance lapse, then that constitutes a default of the entire obligation and may allow for repossession and those things. Okay, so I talked about having a writing of the security agreement. What if we have an oral one? We can still have attachment if we have control over the collateral by the secured party or possession of the collateral by the secured party. Let's talk about control first. Control means the secured party has the exclusive right to dispose of the collateral. Right? So let's use a deposit account as an example. It's a good example of control. This is where the debtor has money on deposit, and the debtor wants to use that money on deposit as collateral for a new loan, for instance. In order to do that, the debtor would have to give the creditor, the secured party in this case, exclusive right to those funds in the deposit account. And they can do that by just going to their bank and telling the bank, okay, I want to give this secured party control over the account, allowing them to take withdrawal, in other words. So for deposit account, we can see here the holding bank automatically has control over the deposit account, or if the debtor has authorized the creditor to have exclusive control. So here's the example. If I go to my bank, let's call it First Bank of WIU, and I want to borrow some money from the bank, and the bank says, well, what do you have as collateral? I say, well, I have some money on deposit in your bank. I have a savings account. It's got $20,000 in it. So they go ahead and loan me the money. We do a security agreement, and I give them the rights to my my deposit account. If that's all I do, and I don't authorize the holding bank to have exclusive control, they still do, because the deposit account is in their possession. It's in their bank, and so they have automatic control over it. If I was going to go to another bank and get a loan, I would have to go to my holding bank and give them the permission to have exclusive control to take withdrawals over to the second bank. So either way, control over the account is all we need for attachment. Or possession. Sometimes we have a piece of personal property that we want to use as collateral. If the secured party takes physical possession of it, let's say I want to borrow money from a bank and I have an original Rembrandt painting that I'm going to use as collateral. It's very valuable, and I physically have the painting. What I can do is, in our security agreement, I can just agree to physically give the painting to the bank to hold until I repay them or satisfy my obligations. This is called, possession. So at the time that my painting transfers possession, I give it to the bank. That's when their security interest attaches, and attaches by possession. Okay, other issues related to attachment. Value. Remember how I said that the creditor has to give something of value to the debtor. It's usually money. but it doesn't have to be. It can be anything of legal value. And then we get into future value. What if the value that the secured party gives in exchange for the collateral is future value, like a line of credit? The bank agrees to extend a $10,000 line of credit. So at any point, all the debtor has to do is ask for money and use part of that line of credit. How does that attach? Or how does that attach to the collateral? Well, the line of credit is fully secured regardless of whether the debtor only takes a portion. So if the debtor is going to give a certain piece of property as collateral and take a line of credit, the creditor extends the line of credit for $10,000, the debtor only takes $1,000 of it. But once the debtor takes even $1,000 out of the available $10,000, then the security interest has attached to the debtor's collateral because that's been giving value, even if it's future value. Also, the debtor, as I mentioned, has to have rights in the collateral in order to use it as collateral. The debtor must have some right to it, but not necessarily ownership. Usually it is ownership. Okay, what about attachment to future property? This is where the debtor wants to use certain property in their possession as collateral, but they may not keep it forever. What about future property? For instance, what we call after acquired property. After acquired property are items of the same description that a debtor acquires after the original security interest. Let's go back to Bob's garage. Let's say Bob has a certain piece of equipment. He has the diagnostic machine, and he wants to use that as collateral. He goes to the bank and wants to borrow some money and says, I need to make my payroll to pay my other mechanics, and so I need some money. The bank says, what do you have as collateral? And Bob says, well, I have this diagnostic machine that I own. Okay, the bank loans him money and they take the diagnostic machine equipment as collateral. And in the security agreement, they will describe it this way. Bob gives the bank his diagnostic machine and all other equipment currently in his possession and any after acquired equipment as collateral. Okay, so what that means is if Bob decides to take his diagnostic machine, if it breaks, for instance, and he gets a new one to replace it, then he doesn't have to go to the bank and do a new security agreement every time he changes out a piece of equipment. The security agreement will cover all equipment now owned and hereafter acquired. And so the bank's interest will attach to everything, all the equipment he has now, and if he replaces a piece of equipment later with more equipment or different equipment, it attaches to that too. So we don't have to run out and do a new security agreement every time the debtor changes equipment or other categories of collateral. We can use what we call the after acquired property clause to cover all of that. And proceeds. Proceeds are money from the sale of collateral. So if Bob takes his diagnostics machine and goes out and sells it to another mechanic and gets $500, the $500 cash is proceeds of the sale of the collateral. And so if the bank had a security interest in the diagnostic machine, they also automatically have a security interest in the proceeds, right? And so once Bob sells the diagnostic machine and gets the $500, the bank's security interest automatically attaches to the $500, which they then could repossess if Bob is